ladies and gentlemen, as an economist, I would like to study the smart regulation approach from a law and economics perspective, and in particular from a private interest theory perspective. Yet, as economists advocate efficiency, are you familiar with these economic theories of regulation, or in particular private interest theories? Yes? Okay. So that makes a couple of slides I can skip. Doing efficiently. The theory I want to concentrate upon today is private interest theories, and in particular the Chicago theory of regulation of Stigler and the public choice theory. Very briefly, Chicago theory of Stigler, very briefly summarized, tells that industry itself asks for regulation, and that, in that sense, regulation can be explained. Stigler borrowed upon the work of Olson, who in a famous work examined why certain interest groups are more efficient than others. And basically the conclusion was that small homogeneous groups are more effective in getting their interests over than large dispersed groups. I could illustrate Olson's insight by means of environmental policy in the European Union. We have the examples of organic farming and wind turbines. For organic farming, there does not exist any explicit goals for the member states to achieve development of organic farming. On the other hand, for wind energy, there exist clear explicit target levels. For example, 20% of total renewable energy must be achieved by 2020. How come? Well, one explanation could indeed be based on Olson's insight that the interest group representing both industries, organic farming and wind turbines, are different. If we indeed study the interest representation of organic farming, there is one interest group, IFORM EU, representing about 300 members, and the group size of organic farming is approximately 186,000. So basically the organic farmers consist of a large and dispersed group. The wind turbine market, you have one interest group, which is the largest one, the EWA, and actually the manufacturers only are very small in number. There are only 15, Siemens, Philips, and so on. So they are a very small and focused group. So that could explain why, in the case of wind turbines, there are clear target levels, but not in the organic farming. Public choice theory, there is Buchanan, who is the most well-known scholar, and he treats regulation more as a political market where the different players each strive to get their own goals. So it's not a government that just follows their interest groups. The government itself has its own stakes. Basically, this is represented by this graph. We have producers and consumers, the most well-known interest groups, but also politicians and bureaucrats themselves. They strive for their own achievement of their own goals. For example, vote maximization or budget maximization. I would like to examine which theory of regulation, either Becker or Buchanan, fits best the regulatory process in the European Union, and in particular environmental policy. Yet before I can start that, just a brief word about lobbying in the European Union. Lobbying has been quite a problem for many years, and due to low level of citizens' trust, in 2008 the European Transparency Initiative was developed, but as you probably also know, it was announced to be very ambitious, but as so many times happens, it has been watered down. So it has become a voluntary registry for interest representatives. Only approximately 1/3 of the interest representatives have registered, so which is not too many, and only moderate information is disclosed on, for example, whom they represent, or their mission, or turnover, and the correctness of data might even also be questioned. I also don't have to remind you about the recent scandals, for example, the cash for amendment scandals, where members of European Parliament were offered bribes in order for official favors by journalists of the Sunday Times, and at least 4 MEPs complied. And very recent, in October 2012, we had the Delhi scandal on tobacco legislation, where the Commissioner for Health and Consumers Affairs had to resign because of an alleged corruption claim in the case of Swedish snuff. So there is lobbying going on, and it's not that rosy and fantastic. But my main question is, how should we evaluate the impact of that lobbying on smart regulation of European environmental law, and being academically, which theory of regulation fits best the situation in the European Union? I would like to take the example of the Environmental Liability Directive. Can we compare the lobbying process or the development process of the directive with either Becker or Buchanan? The Environmental Liability Directive provides a framework of environmental liability based on the polluter pays principle to prevent and remedy environmental damage. The directive covers damage to biodiversity, water pollution and land contamination, and foresees liability for the operator of an occupational activity, and then it's split. There is strict liability for operators of risky or potentially risky activities, which are included in the annex of the directive, and we have full liability for operators of non-listed, so non-dangerous activities. And then it also only applies for damage to biodiversity. Well, although the whole development process of the directive has taken more than 20 years, the transposition of the directive has been very cumbersome. Only 3 member states could transpose the directive before the actual deadline. The question obviously is, why was that? They had apparently enough time to think about it. Well, final elements of the regime were passed on to the member states, and that were not just minor details, but basically crucial elements of a liability regime, as for example the inclusion of defences or obligatory financial guarantees in case of damage. The question obviously is, if they had taken so many time, why were so many provisions left to the member states? And then it's very interesting to have a look at the various takes of the stakeholders in the environmental liability development process. Industry and the environmental NGOs can be considered as the traditional lobby groups. And basically, they were, after a certain time, industry certainly, pro-European regulation in the field of environmental liability. But obviously, industry wanted to have a kind of level playing field, but a rather moderate level playing field. So they fiercely lobbied for the insertion of defences, and obviously they did not want any obligatory insurance. Environmental NGOs obviously wanted to have the opposite result. They wanted to have a strict European environmental liability regime that would protect the environment in the European Union, and obviously they did not like defences or the absence of financial guarantees. These sides standing, or these both groups being opposed to each other, one must also consider the European regulatory institutions themselves, and the Commission. Well, one could argue that the Commission just tries to hear the voices of different groups and makes regulation, but one cannot ignore that the Commission, by having an environmental liability regime, opened up its competences to fields where it did not have competences before, as for example soil protection policy. In the Parliament, most members were pro-European, but there was disagreement between the Legal Affairs Committee and the Environmental Committee. and in the Council, most member states agreed upon a European level or European environmental liability regime, but obviously they all differed on the aspects of the regime, on the content, financial guarantees or not, defenses or not, and that depended a bit on their own history and their environmental disasters that they experienced before. So all these different stakeholders in the negotiation process, they try to achieve some of their stakes, and the result is effectively a European environmental liability regime, but as we could not agree upon one regime, the decisions on final crucial elements have been passed on to the member states. There is, for example, a limited scope of the regime, which member states can adapt a bit. They can choose for the insertion of permit and or state-of-the-art defense. There is no subsidiary state responsibility for damage that cannot be restored by the operator, and there is no obligatory financial guarantees for operators facing strict liability for dangerous activities. That obviously means that the impact of the directive depends on the implementation of the directive in the member states, and not only the implementation, which can vary a lot, but also, of course, the enforcement. But we are still waiting for more results about that. But in first sight, the transposition has been very diverse, and up to now the directive does not have so much effect yet. Can we connect this to these private interest theories? Becker, Olsen or Buchanan? Well, with respect to the level of regulation, one could either argue that the Commission just took into account the preferences of the Member States, environmental NGOs and industry, and therefore developed a European environmental regime at European level. Yet I think that would be rather naive. I think a second explanation is more likely, rather that the Commission welcomed the European environmental liability regime for also other reasons than the public welfare and protection of the environment. The ELD was a means for enlarging its own competences in, for example, the field of soil protection. So I think it resembles more Buchanan's theory of government behavior. With respect to the content of the directive, probably it is clear that industry lobbying was most successful. They obtained the defenses, basically. Most member states also inserted defenses in their regimes. They have no obligatory financial guarantees, for example. So the strength of the lobbying industry was better, so to say, than in environmental NGOs lobbying. So that might fit into Olsen's theory of successful single-oriented lobby groups, rather than Becker's theory of competition and an efficient result in the end. Is there a winner of the lobbying process? Well, probably industry and the Commission gained most from the directive, either in terms of a rather lenient regime or in terms of competences. So how should we now evaluate the lobbying on the decision-making process? In principle, if we get all information and if all lobby groups are equally represented, Becker suggests that lobbying also will lead to efficient regulation, hence better or smart regulation. But as we can see by the case study of the Environmental Liability Directive, it's by no means sure that interests are equally represented, and lobbying regulation is far from optimal to ensure better or smart regulation. So therefore, I think that there might be some recommendations to be done. One might think about the mandatory lobbying registration, where clear definitions exist on who must register and which information must be provided. Clear sanctions and fines must also exist for unethical behavior, And in that respect, maybe lessons can be learned from US or Canada. And of course, research is necessary or can be effective to examine the effects of regulation. And in my view, that would also bring us a step closer to smart regulation. Thank you.